You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 392 of the Immigration Lawyers Toolbox podcast. I'm your host, regular host, John Q. Khosravi, immigration lawyer, coming to you live from Los Angeles, California. And we're doing our regular weekly, it's the second week in a row, so it's weekly, top 10 episode things I learned and I wanted to share with immigration practitioners. And so we're going to get started with that. The most important thing, frankly, I want to share is that the EB1A course is out. If you're thinking about getting into extraordinary ability cases, expanding your practice, or getting better by getting second opinion on the law, seeing redacted samples, getting mentorship, that's part of the program, just let me know. Info at immigrationlawyerstoolbox.com. We'll get you on the course. If you're already part of our circle.so community page, just click on the EB1A link and you can purchase the course there. If you're not already a member, it's a free group and there's tons of white label content, AI analysis of AO decisions, synopsis, other CLEs, and a lot more. Just email me with your bar information, your full name and state bar and bar number, so I know you're a lawyer. It's for private practicing lawyers only. Info at immigrationlawyerstoolbox.com is the email, and we'll get you in. We already have hundreds of members there, and we're getting hundreds of more this year. So it's going to be a really active place, and that's going to really take your practice to the next level, whether you're starting or whether you've been doing it for a long time. Just to give you a heads up, too, we're doing a combo at a special price so that the EB1A course comes with our recording of the O1 seminar we did live in Los Angeles a few years back with top O1 lawyers in LA coming, David Malik Telfer, Flavia Chloe Santos, Jerry Marshall, Joseph Zhang, Nicholas Moros was there. I spoke, and we have one more colleague, which I'm blanking out his name, but I appreciate him too. Sorry, brother, but it's great immigration lawyers that can really help you take your practice to the next level, especially all the craziness going on the removal side and humanitarian side. This stuff's not going to be easy, but get the heads up you need to get things started in a way you could trust. So just email me to get started on that. Info at immigrationlawyerstoolbox.com. Magazine is going to be published pretty soon. We got all the articles we need for the magazine. I got to just proof the article as much as possible, get a cover on there and get it out. Probably it's going to be an August release, a summary issue. So the timing is still pretty good. So check that out. If you want to see our old issues of the magazine, our previous ones, and we try to get evergreen content, so it's going to be helpful. Go to our website, immigrationlawyerstoolbox.com or just iltbox.com. Click on the magazine link and you can check those out there. We just changed our hosting for our magazine. So if you're a previous person who watched we would follow our magazine, you'll see a slightly different, but the previous magazine publisher quadrupled his price overnight. That was kind of crazy. So I'm like, let me find an alternative, and I found better stuff. So that's actually half the price it was. So you got always. I guess as a side tip is that one thing I've been doing. I listened to this podcast about business, and they were saying one of the biggest things is when you're running your own firm or business is the creeping up of bureaucratic costs and everything. You got to constantly go over piece by piece every piece of expense to see what is it, what was it, can I do better. And so last month I went through all the different things we have, and some of them were really expensive stuff. And I tried finding alternatives, but I couldn't find a decent alternative, so I stuck with what it was. So it was spent a lot of time to realize like what we have is good, which is worth it. But on the other side, I just got rid of a lot of software we were using or was redundant. I checked out certain software we saw that did the activities that we weren't using it for full potential. So we got rid of one software and added this one. And sometimes we have software that does other things, but the other things it does is not up to par. So we still have a separate system for that. But you got to check it out to reiterate whether it's good or bad. And a lot of these people keep adding features, so you just got to know it's there and not miss out on it. Sometimes you can negotiate a fee too. So I canceled a couple pieces of software, and when I canceled them right before we're at the end of the page, it said, okay, we'll give you like 75% off for 1 year. And it's like, I'm not sure which ones will always do that, but it's a game you could play, a game of chicken, to see if you get to the almost cancellation page and you get their massive discount in price. Because almost all of them had something like that at the very least. Not 75%, but like between 25 to 7%. Pretty like extreme kind of discounts try to keep you. because I was going to talk about this here. I'm saving this for a business top 10, but the cost of bringing on a new client is so high, and the costs are so low of maintaining a client that it's worth to strip the prices down. Sometimes keep a client that's going to keep coming, but I'm gonna keep that for a business top 10 episode today. I'm gonna focus on the law. So having all said all that, none of the information presented here is intended as individual legal guidance. Please consult with an immigration attorney about your case, but you all know that already. Let's get the show started. All right, number one. And I was this wasn't number one this morning. I just saw a post on it, and I'm experiencing them as well. I don't typically do humanitarian cases like use or something like that, but I one of my existing business clients got a U case, so he filed it, and it's been 2 months. We haven't got a receipt yet. I had seen posts saying how much it gets delayed, but I saw a Facebook group post where someone asked, "Hey, how long are you guys getting taken to get a VAWA?" VAWA U visa, particular was the question, but this I've been seeing this with VAWA too, and people were saying, I just got a receipt from a case filed in March. Right now it's July when I'm recording this. So this the third month, the seventh month, that's 4 months. Some are saying January. So there's like a 4 to 6 months delay in getting U visa receipts, which is a disaster because if people are worried, they don't have any paperwork to show anything. But unfortunately, that doesn't necessarily help out much anyways now. So our second of the top 10 is there was a class action lawsuit about SIJ cases not getting deferred action, cancellation of deferred action. Our colleague Rekha Sharma Crawford, well known for her battles against, Lozada and how that system is designed. She's on the show too, great immigration lawyer. But she posted on LinkedIn that the ACLU of Florida and Americans for Immigration Justice have sued the administration over inhumane conditions at Alligator Alcatraz. Essentially, related to that are something that was lawsuits filed about the Sigis cases. And so, but we're seeing these delays in VAWA and U visa, not only receipts, but also the issue of, being in a peer to authorized state, essentially, where there was deferred action for VAWA, U visas, SILEs, asylum pending. We're hearing all the time people with asylum pending with EADs getting picked up and sent to Alligator Alcatraz. And there's also where people with adjustment of status pending, people with change of status pending. Let me move that up. Actually, I was going to make a comment a little bit later, but let me move that to right here. Number three top tip of the week. And this was really important for those doing business. They're getting people and NTAing them if they're in their H-1B grace period. So if an employer has an H-1B with you, you leave and go to a new job or you're fired, they submit a notice to the government that the employee is no longer with them. Instead of giving him some grace period time to get a new, essentially do what's called colloquially an H-1B transfer, they're NTAing these H-1B employees. They've been legit. They just lost their job. They're just going to switch their H-1B new one. The tactic is, well, you're out of status. We can immediately NTA you. Very crazy situation that they're putting people under. There's going to be lawsuits, obviously, about this. But the main thing they're trying to push by doing all this stuff is obviously there's no safety if you're an immigrant in the United States. That's just the way it is that the administration is focused on. So, how do you guide clients on this? I don't know. So, just be scared. And the next problem then becomes a tip number four, or note, unfortunately, it's not a tip, but it's the Trump administration fired 17 more immigrations last week, their union says. The Trump administration, according to an article by Haley Carnoth, the Trump administration has fired 17 more immigration judges, bringing the total of immigration judges that have been either terminated, transferred, or accepted retirement offers since January to 103, according to an announcement made Tuesday by the union that represents them. So it's a major disaster getting rid of judges. I have colleagues that are posting that some judges are in the middle of a hearing and they get an email saying you're fired and have to stop immediately. And obviously, it's the judges who are more reasonable in their adjudication standards. So it's going to be even tougher fight for those doing removal defense. It's just how people are going to have representation in that field. It's gotten so hard, and it's just an insane situation. So that's that right there. I guess that's a good segue for me to plug again the EB1A course. The EB1A has its own headaches when you're dealing with the agency, and a lot of people have to do lawsuits to get them approved. It's still an additional pathway for you to be able to expand your practice, deal with very interesting clients that are high value cases as well. And it doesn't require you to leave your house or your office. You don't have to drive downtown, sit in a courthouse, get yelled at by a judge or by ICE, feel the irrationality of it face to face. It's something to add to your repertoire. And the value of each case is so high, you don't need a million of them. Just got to get some flow out there and it increases both your bandwidth and your practice and all this kind of stuff. Definitely something to look into. We have a course, the EB1A Ultimate EB1A Extraordinary Ability course with O1 seminar, so you could have that pipeline from O1 to EB1A. I was talking earlier about the importance of what I was talking about in the intro of businesses that keep clients going. This is really it. So if you have an O1, you got one client, you repeat that O1, eventually they get to EB1A. That's like an easy client. We're gonna have to spend as much revenue or time to attract new clients because you have an existing client that's repeat. Eventually gets a green card. They get married. They bring spouse over. They might have our spouse doing consular processing. There's the adjustment status portion of the case. Eventually they become citizens, naturalization, and from there they do I-130s. So it's a long term case. That's why the more you practice immigration law, the more clientele you accumulate, and you have good service. Obviously, that the business it grows on its own because you accumulate more people that are keeping the business going, and you come back for more services. That O1 EB1A pipeline is definitely one of us helpful. So definitely check that out. Email me info@immigrationlawyerstoolbox.com. It's for lawyers only. Let's go to number 5. So the U.S. Big Beautiful Bill, the BBB or whatever it's called, has a condition in it of adding a $250 visa fee, and it's going to really impact the U.S. Dramatically when it comes to travel. It applies to all non-immigrant visas, essentially, tourist visas, H-1Bs. And so that's becomes a major problem because imagine you're a family of four wanting to come to visit the United States. You had to spend an extra $1,000 after visa issuance, and allegedly you can get the money back. But there's gonna be problems with that. How much headache it is to get that back. And the worst part is the DHS secretary can increase that fee on a whim. So it's a very unnecessary aspect. It's like shooting yourself in the foot. We have so many people that visit here, millions of people visit here. They'll have to spend all this extra money. That's less money that's going to be spent on the businesses when they come to the United States. So the idea is this saves some sort of I don't know what in the world kind of idea that is or where that comes from. But that's $1,000 less that are going to be spent in the United States because it's going to be stuck in the visa office. And so it's just the mindset of the people creating these bills. Hopefully, that's another one that gets stopped. So imagine if you're doing like a E2 visa, which is probably I think this would apply to already. And A lot of visa, like Australia, has a crazy high visa reciprocity fee. Let me see if they lower it or not. So if you don't know already, you don't do consular processing. The U.S. has like arrangements with every country called, and it puts it on the visa reciprocity chart for the State Department. And if you go to visa reciprocity chart for each country, it'll list how their documents are supposed to look like the birth certificates and passports and stuff. But it also lists how long we give certain visas for each country. So, for example, from some countries, you might get a tourist visa, but it's only single entry and valid for 3 months. But if you look at Australia, for example, under B2, I'm not sharing my screen, but it's a multiple entry 60 month or 5 year visa, if I do my math right. 5 years? Yeah, 60 months, 5 years. And so that's that. But if you go to the E2 option, it says visa classification like E2. There's a $5,592 reciprocity fee, essentially because if E2 visa is a treaty where both sides could go each place, so an Australian citizen can come to the United States and start a business, but they got to pay this per person visa fee of $5,592. In the U.S., Americans probably go to Australia to do the same, but they'll probably have to do this fee too. Last time, first Trump administration, update all the fees to match what other people do to us, so it's kind of like a both sides are being nasty with it. But imagine it's like a family of four is already 20,000 plus there for visa reciprocity fees, and add another thousand. I guess not that much more, but nonetheless, it's a lot to add on top of this and top of that. So a lot of money flying out. Let's go number 6. Reports of significant USCIS FOIA sections either being withheld or redacted and not doing adequate searches. So it's something we're seeing ourselves where we're getting USCIS FOIAs back with chunks and chunks of it just blackened out, not bothered to look at, or cases where they're saying we can't find anything, we know there's something there. There's CBP FOIA has always been something that's problematic, takes them forever. Sometimes responding, we don't have anything, we know they have anything. So the FOIA situation has gotten terrible, and it's very bad because a lot of times we need copies of the file to figure out what's going on, and it creates a black hole, or not a black hole, but unknown aspects of the case that we can't discover because of that. And then, we do EOIR FOIAs recently now for a lot of our cases, and we're doing adjustment of status just to double check the case now with the court. We're luckily getting those back pretty quickly, 3 to 6 weeks after requesting it, not faster. So that's good there for the most part. At least we know they're not in court. But the fact that the USCIS reactions are coming like this, it's a really annoying situation. So let's go to number 7. This was an interesting one. I had a consultation with a couple that were going to want to do adjustment of status, but I learned that the foreign applicant originally entered as a K-1 visa holder, and the relationship didn't work out, so they withdrew their case. Unfortunately, their attorney didn't give them good guidance. Their relationship was amicable in the sense that the U.S. petitioner would have kept the affidavit of support alive if they knew this was allowed under Matter of Sesay, which says that if you're on K-1 fiancé visa and the marriage falls apart, you could still adjust status if the affidavit of support is there. Now, whether USCIS still approve it, being relationships, all that kind of stuff, will yet to be seen. But that's Matter of Sesay. A lot of people know about that. But I was studying up on the law in this because you have a console. I'm going to get updated. So I went and studied like the 4 or 5 cases that were there, but some BIA cases, some federal court cases, and there was a case. And unfortunately, I didn't save the case to cite it, but it said that if you came on a fiance visa and you got married, adjusted, and then you get obviously usually you get a 2-year conditional green card. If the conditions on the green card are not met, conditional requirements are not met, you don't get a 10-year green card, you revert back to the status you had before you got the green card, a K-1. And then at that point, as the requirements are for the K-1, you can only adjust based on marriage to that original U.S. citizen. And so in these cases, if you get remarried or something like that, it doesn't you can't adjust because you revert back to the K-1, which is I guess another negative notion part of the K-1 visa. It's like I try to avoid doing K-1s because of all the ridiculousness right now with the travel bans, for example. K-1 visa is not part of the exceptions that immediate relatives are a part of. So those people that did K-1 fiance visas think it would be faster. Got to get married now, file I-130s, and go through all that. And so that's the situation with K-1s I usually avoid. But sometimes there's some positives to it, I guess. But seeing that the I-751 denial reverts you back to a K-1 and you can only adjust based on the first marriage is such a weird situation that they did something like that. So what happens if you're still good with the petitioner? You then like readjust and file an affidavit of support, and if they're willing to do it, and you adjust again. Now, will they believe the marriage is real? Will they accuse you of marriage fraud, which is even worse kind of thing? I was asking ChatGPT about this, and it kept saying that although you can do Matter of Sesay and like submit an affidavit of support after a divorce happens, if the petitioner still allows it, in practice, USCIS doesn't really do it, and it's more of an EOIR thing. They're more amenable to it. But I mean, I haven't done a case like that, but I don't think that's necessarily true or not. So you got to be careful what ChatGPT says. And it kept saying like BIA decisions not binding on USCIS. Then I cited the 8 CFR section. We did an episode a while back where I definitely check it out. This episode didn't get many views, but it's like one of the most important ones. Let me find the number so you reference it. This is episode. Going back to my backlog on the podcasts. 8 CFR. It wasn't February. Essentially, I analyzed the 8 CFR section 103, top like 7 things you should know for USCIS filings under 8 CFR 103. And one of the notes was that USCIS is bound by BIA decisions, and so ChatGPT was saying that has to be like a recognized decision, but like Matters to Say is a recognized decision. That's case law. So, but I was surprised it said that. So, take it for what it is. But listen to that podcast episode because it's really good. But just beware of this K-1 nonsense. Number 8, I'm writing a guide right now about naturalization for my law firm to help marketing, that kind of stuff. And so I was reviewing the policy manual, in particular, volume 12, part B, chapter 4, about administrative closure for failing to appear at initial interview. Now, in practice, I've had clients that just miss the interview for naturalization. It's a naturalization tip, I guess. And what USCIS historically would do, I've had this happen 3 or 4 times, and not for the last 5 or 6 years, but a long time ago. USCIS would just reschedule the NATS interview. It wasn't like AOS adjustment where if you miss it, you're going to get denied in potential NTA. Well, here it says an applicant abandons the application if the applicant fails to appear for their initial naturalization examination without good cause and without notifying USCIS for the reason of non-appearance within 30 days of the scheduled appointment. In the absence of timely notification by the applicant, an officer may administratively close the application without making a decision on the merits. So I'm not sure how long that came to law, but just be aware that is the rule. In practice, they might not always do that. It goes on, applicant may request to reopen an administrative closed application without fee by submitting a written request to USCIS within 1 year from the date of the application was closed. So that's good. They allow you to open it with no fee. So that was interesting. I want to share. The date of the applicant's request to reopen application becomes a date of filing the naturalization application for purposes of determining eligibility for naturalization. Oh, I didn't even I copy paste that part. I didn't read that part. So the reopening date is when the good moral character situation. So I guess one thing you can do is if you know you're going to get denied because they have some issue, don't come to the interview. Put an administrative closure. Wait till almost a year, then request that'll be reopened. And I mean, maybe easier just to file a new naturalization case, but that's interesting right there as a strategy. If the applicant does not request reopening of an administratively closed application within 1 year from the date of the application was closed, USCIS considers the naturalization application abandoned and dismisses the application without further notice to the applicant. Now, again, in practice, I've seen them automatically just reschedule a new interview a month or two later, so it doesn't give you the time to miss it. And this is this section of the policy manual is specifically about administrative closure for failing to appear at an initial interview. So if you miss the second one, they'll just deny it. So although this is what the policy manual says in practice, I don't think it's actually going to happen, but that was an interesting thing to read and get out. Number nine, a great listener, one of the first listeners to the program, Lawrence Wolfers. I saw a post of his. I guess I'm sharing without permission, but I mean, it's information. Thanks, Lawrence. As someone I posted that they tried to get a boarding foil from the consulate, but they were not giving it for a client who lost their green card. And he mentioned you can reach out to, again, this is not always going to work, but this is something he's tried. I guess you can reach out to CBP at the port of entry. They can give pre-clearance and notify the airline, which will allow the airlines to let the person board. Upon arrival in the U.S., they'll have to sign the green card holder have to sign an I-193. That's like a form for not having proper entry documents, I think. And there's a fee for that. A lot of times they waive it and pay a fee, and CBP can admit them without the green card. So this was again a person who left with expired green card I-751, but lost the green card and was unable to get documentation from a consular officer to show that they have a green card, making boarding difficult. So that's something to do extra work. But hey, that solves having, because imagine if you lose your green card overseas and getting I mean, CBP will probably usually tell you to go to the embassy unless the embassy specifically says no. But there's a form, I think it's I-131A or something like that. You got to pay a bunch of fees, go to the embassy, and you have a return flight. What a nightmare it is to lose your green card if you're traveling. A horrible situation. But that's our passport, all that kind of stuff. It makes you not want to travel. And number 10, the last one. Thank you for all listening so far. Number 10 says matter of K dash E dash, it's not dash, it's hyphen, E hyphen S hyphen G hyphen. This is a BI decision 29 INN December 145, BI 2025. And the decision says we acknowledge that sex is an immutable characteristic. See matters of Acosta, recognizing sex as an innate characteristic, overruled on other grounds, a matter of Khosravi, 1987. However, not quote unquote, not every immutable characteristic is sufficiently precise to define a particular social group, matter of M-E-V-G. A proposed, and this is like the big crux of it, a proposed particular social group based solely on sex or sex and nationality must also satisfy the particularity and social distinction requirements for a cognizable group. The court here rejected a particular social group of El Salvadoran women or Salvadoran women and Salvadoran women viewed as property. So, I don't do humanitarian cases, but I saw this seems like an important one that's going to affect a lot of people. So I wanted to at least put it out there that this matter of KESG came out on immutable sex characteristics and how that plays out, so you can use it for your practice. Thank you so much, everyone, for listening. I hope this information helped. For sure, there's 10 different things I said in there. There's going to be 2 or 3 of them that made your practice better. More of a reason to continue listening to the Immigration Lawyers Toolbox podcast. Hope to have these all out on Monday of live recording, and the actual recording, but you're listening on a podcast might be a little bit later. But I remember when I used to do these regularly, audience quadrupled, so I'm getting you back into it. And the clips of all this is going to be available too. Definitely follow us on Instagram, where we post a lot of these clips, and LinkedIn on my John Q. Khosravi page, but also the Immigration Lawyers Toolbox. But for Instagram pages, Immigration Lawyers Toolbox, I think that's the name of it. But we got a lot of, I didn't realize, like when I was at the conference, AILA conference, when people found out we have an Instagram page, immediately followed us there. I don't go on, I post a lot on social media if y'all probably see it. But I don't use social media much at all. So I never think about like people going on Instagram and using it. But apparently a lot of people do. So follow us there. I get so many client the other day that found us on Instagram. The K1 client that I talked about, that tip about Matter of Sesay, they're remarried. They found us on Instagram, and I was really surprised about that always. But Instagram, YouTube are the best when it comes to marketing. TikTok is used to give me a lot of views, so it was like a high they'll give me, even though the clientele either we're not there or they have money or not the highest end quality clientele. But recently, the same YouTube, the same TikTok short video I do, if I post it on YouTube, it gets like 4 times the viewership. So it's the big switches happen on TikTok. But I appreciate what TikTok for it was, because it allowed me to like get in the habit of posting short form content repeatedly and just boost my marketing when 2020. So much appreciated there. It's kind of changing the app, and I think they're being sold or something like that. So there's going to be a big change happening there. But hey, that's the speaking of, I was saving this for the special business top 10, but I spent a lot of time making videos, and not that a bulk of our clientele from having a year's worth of statistics now, based on our CRM system, who comes client and from where. Bulk of our client are returning clients, and that's why I made that mention earlier in the show. And then secondly is referrals, which never thought they were that big, but they're referrals from other clients. And third is from social media. It's like a far distance. But the reality is we work hard on the social media videos to get that one client who then becomes a return client, who then refers people. And it warms people up when people, even if they get referred to us, when they see our videos, all that kind of content, they like, okay, this guy knows what he's talking about. They're into it. And I've even had people who had other immigration lawyers leave their immigration lawyer because they saw my content. Like, I'd rather just work with this guy. So, just how you kind of present yourself. I see some people's videos. I'm not the biggest social media pages. So I'm not like the big expert on it. I don't have 100,000 followers, something like that. But I watch some people's content on social media, and it's like, don't even bother. Like, it's not good. The stuff you're talking about, or at first you just say, hey, good to meet you. You gotta learn the tricks of it. You can't spend like the niceties for 10 minutes to get into the show. Even though our podcast, I spent 10 minutes in admin at the beginning, but it's a niche trade podcast, so you guys could deal with it. If you're going on social media trying to catch people's attention, it's not the way to go. You just got to kind of fine tune your stuff, which is what I'm trying to do in the podcast. So I'm going back to doing consistent publishing and formats and all this kind of stuff, and just to make this into a more full functioning business after all the expenses of going to the AILA conference this year. I got to make the most of it. And you should do the same with your practice. Keep it serious. Update everything that you can. Look at the numbers. Revision things, revision logos, the website. It's a lot of work, but you got to constantly keep going at it. We've been updating our website piece by piece constantly, and we've gotten more views every 4 to 6 months. I find the time to do work on my website and our Google Analytics. Every time I do that, we double the amount of searches we get. So it's like I just got to keep doing that on a regular basis. But that's the ups and downs of the, I guess, bad systems that I have, where it's like I'll do a bunch of stuff for a couple months, it works, and get too busy with something else, and that falls to the way. That's been the story of a 15-year law firm. But it's good to have time to do these podcasts and having a good time with it. And hopefully I get better at it. I get a coach in there or something. I don't know. But EB1A course, Extraordinary Ability, get it, get it, get it. I'm immigration lawyer John Khosravi. Thanks so much for listening. I'll catch up with you all soon. Bye-bye. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.